However, we are asking that you give him that chance. My client is not a child anymore. He's an elderly man at this point.
To the plea bargain agreement, it's a cap of 6. The state is remaining silent on your application. Calling 2021 CR 4788, State of Texas versus James Lawrence Stegmeyer. Could I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
John Coons for Mr. Stegemeyer.
And are you Mr. Stegmeyer?
Yeah.
Are you Mr. Stegmeyer? All right, you entered a plea to count 3, which is indecency by contact. You entered a plea of no contest on September 13th. There was a request for a PSI report, TAP evaluation, and MIG-MILF evaluation. And of course, through the nature of the offense, he's not going to be eligible for MILF. But have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Yes, Your
Defense? Any objections to the PSI report, state?
No, Your Honor.
Defense?
Honor. No, Your Honor.
According to the plea bargain agreement, it's a cap of 6. The state is remaining silent on your application. All right, defense, is there anything you wish to say on behalf of your client?
Judge, if you'll recall, this is an individual who I struggled with, not with him personally, but because he had been diagnosed with dementia about 20 years ago by the VA. This is something that I had him evaluated for. Dr. Scott did at least one evaluation. I provided numerous documents to Dr. Scott and to the jail where my client's been sitting for the last year and a half or so. Unfortunately, unfortunately, Dr. Scott found him to be competent and did not see the same issues relating to my client's Parkinson's that the VA did. With regard to all of that, obviously I trust Dr. Scott, having known him. He's been around for a long time and I understand his evaluation. I had him actually reevaluate my client based upon some additional information that I provided. He sent back a further evaluation stating that it didn't basically change his opinion of things. At that point, Judge, my client and I decided that the entry of a plea would be in his best interest. Judge, it's never easy for you to have cases like this in front of you with victims and especially someone that was at the time. I would tell you, Judge, though, that—
Excuse me, I'm sorry, just a moment.
Mhm.
All right, yes.
Okay. Let's see, where was I? With regard to cases like this is obviously difficult for a court to even contemplate probation sometimes. However, we are asking that you give him that chance. My client is not a child anymore. He's an elderly man at this point in his life. And given all the health problems that he's had and with the Parkinson's, with the other issues that he has, I don't think he'll be any sort of danger or risk to the community while he's on probation.
So counsel, does he have dementia or does he not have dementia?
Well, so he has Parkinson's and the VA has diagnosed him with Parkinson's related dementia. This goes back approximately 20 years. Again, as I was telling the court earlier, I provided all of that documentation to Dr. Scott. Dr. Scott met with my client and had determined on 2 separate occasions that my client is not incompetent. So, I'm not sure what I'm supposed to do beyond that. And the reality, judges, I have not seen maybe the signs of dementia that would cause me to request a second doctor to evaluate him. Dr. Scott did the 2, and
Excuse me, Deputy Laura, you've dimmed the lights on us. You've dimmed the lights.
so,
Yes.
Judge, I would ask that you do give him the opportunity to be placed on deferred adjudication. He will have to register.
I'm sorry, Deputy Laura, you dimmed the lights. I mean, there's a lot of things wrong with it, but I mean, we are close to October 31st. Okay. All right, yes.
So, Judge, again, with regard to my client's sentence, we're asking that you give him the opportunity on deferred. He will have to register as a sir. We understand that. He understands all of the conditions that he will have to comply with. The probation will not necessarily be easy for him. This is, again, with his health issues. I do believe that a placement in the MIC unit, if that's possible, would be very beneficial to them. The one last thing I'd like to point out, Judge, is that the complainant did not communicate with the probation department. I know that that's not necessarily something that can be examined one way or the other, but this is not a complainant who is raising Cain with the court or raising Cain with the DA's office about what should happen to him. So I would ask that you, given all of the information that I've provided to the court, that you consider that my client's application for deferred adjudication and place him on the deferred.
All right, Mr.
Judge,
Sec,
I know we're silent, but this is a factual issue. The victim is here after sentencing to provide a victim impact statement.
okay. All right, and so, Mr. Stegmeyer, I want you to know that I've listened to what your attorney has said. I've internalized it. And I have read and combed through the PSI report to review everything. So what I can tell you in this court, and I think your counsel knows this, for me, I look at each case individually. It does not concern me, or I don't take into my consideration of sentencing whether there's media, not media, because to me, each case is supposed to be looked at individually and sort of in a vacuum of that case. The same way I tell jurors not to pay attention to anything that's on the news, I do that as well. All right, is there anything you wish to say?
No.
All right, the court is going to deny your application. The court will find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's to be no contact with any minor children, no contact with any of the complainants in this case, or the complainant's family, and Chapter 62 compliance. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney? Did you understand it? And did you sign it?
Ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You said there's. Court is calling 2023 CR 10633, State of Texas versus Devin Heflin. Could I have parties announced for the record for the state?
Alex Jackson.
Defense?
Or Alexander from Meredith Chacon for Mr. Heflin.
And are you Mr. Heflin?
Yes, ma'am.
Any objection to this attorney standing in for Ms. Chacon? All right, so what is happening, Mr. Heflin, is this is an attorney that works in the same firm as your attorney, Ms. Chacon.
Yes.
My understanding is that a plea bargain agreement has been worked out between Ms. Chacon and the state. All right, so Mr. Chacon probably had to go to another court. So this attorney is standing in for her. My understanding is that this attorney is not here to change your plea bargain agreement. He's just here as an attorney standing in for Ms. Chacon so that the plea can be completed. If you would like, we could wait for Ms. Chacon to come back, or either you can go forward with this attorney. Which do you prefer?
You said you work with her?
We're in business together.
So you know all her cases though?
Yes. She knows mine.
All right, do you want to speak with him?
Yes, ma'am.
All right, if you all will step back and talk to each other.
Please hear your comments.
Okay,
I'm sorry.
all right,
I had to take comments.
no problem. And for the record, for defense?
Meredith Chacon for the defense, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, Mr. Heflin, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. I did understand it.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Heflin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison, and there are no applications. And I see outside the agreement, there's a request for an affirmative finding of family violence. Did you understand if I find that there's family violence and that this is a case of family violence, and I enter an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Oh, yes, ma'am.
And did you understand you would not be allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
All right. And also, if I find that there is a deadly weapon involved, there will be an affirmative finding of deadly weapon. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, ma'am.
defense.
Yes,
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
no, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting no contact with Kaydin, Kaydin Butler and James Butler, affirmative finding of deadly weapon and affirmative finding of family violence. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Stand up for State Exhibit 1 with all attachments.
And Your Honor, we have no objection. I have gone over the attachments with my client.
All right, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Also, I forgot to ask, are y'all proceeding on both counts?
Yes, Your Honor.
Yes,
And are you pleading no contest to count 1 and count 2?
Yes, ma'am.
Okay. And are these counts to run concurrent?
yes, Your
The court, no problem. The court will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was on a parole that had been transferred here to Bear County and would like you to give him credit for that time to run concurrent as well. The state had no objection, is my understanding.
No, Your Honor.
All right, and which, do you have a cause number or anything?
You might.
And the court will find you guilty of count 1, guilty of count 2.
And for the record, Your Honor, the victims are also aware of this, Your Honor, and in agreement with this. And I do have the case number whenever the court is ready.
Okay. Count 1 and count 2 will run concurrent. And then what is the cause number for parole?
19 CR S 238347. It's out of North Carolina.
All right, and the court will give you credit for any time served in that cause number and credit for any time served, of course, in this case. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Caden Butler and James Butler. And I'll sentence you to 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not in the state, Your Honor.
No, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea, because I followed your plea and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed, and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
20. I just turned 21 2 days ago.
All right, so I don't know what was going on with you at the household or what's going on with you in your life. If there's a mental health issue or anger issues, that's something that you're going to have to work on. Otherwise, you may find yourself living in a prison. You understand? And when you get to the point in Texas where they stamp you as a habitual, that means in some cases your minimum sentence is 25 years. You understand? All right, do better, okay?
Will.
All right, good luck to you.
Good luck.
Appreciate it.
It appears that this is something that was happening over time. You're saying that they didn't allow her to come back to school because she continued to pull off her mask.
Yes, ma'am.
Do you feel sorry for what you either did or failed to do for your daughter?
I am asking for leniency.
2023 CR 4168, State of Texas versus James Michael Kennedy. And defense, if y'all could move to that end. Could I have parties announced for the record for the state?
For the state, Your Honor.
Defense?
Anton Hayek, what'd you ask me to do, Jed?
No, I'm asking your name.
Anton Hayek, but they
Yeah.
told me to move one way.
No.
Okay.
Okay. So Mr. Hayek, for the record, is representing Mr. Kennedy. And are you James Michael Kennedy?
Yes, Your Honor.
All right, you entered a plea to the offense of assault, intentionally knowing serious bodily injury by omission. You entered a plea to a cap of 35 years in the prison. The state is opposing your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
I've had a chance to review it. I've reviewed it with my client and given him an opportunity to read it at his own pace.
Okay. All right, any objections to the PSI report, state?
No, Your Honor.
Defense, any
No, Your-
objections?
No, Your Honor.
All right, state, any witnesses?
No witnesses, Your Honor.
Defense, any witnesses?
Mr. Kennedy, please.
All right, Mr. Kennedy, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record, please.
My name is James Michael Kennedy.
All right, counsel?
Mr. Kennedy, would you say this event with your daughter finding out about cerebral palsy and having her removed from your presence because of lack of proper nutrition was a real eye opener to you?
It was.
Okay.
Yes, sir.
I'm sorry, could everyone please whisper? And counsel, if you could speak up for me, please.
And during the first 10 years of Michelle's life, did you think there was anything unusual about her not being able to eat solid foods? Well, other than that, she probably should have.
Given her state with cerebral palsy, I didn't know.
And the primary caretaker, Michelle, was Norma, is that correct?
Yes, sir.
And you live with Norma, you're not married to her.
Yes, sir.
Did Norma ever have any complaints to you about something she wasn't allowed to do for Michelle?
No, sir.
And you've read the report and you're happy with Miss, I can't do her name, Sitsu, the foster mother?
Yes, sir.
Okay, and I read you the expert. Do you agree with what she wrote?
Yes, sir, I do.
Okay. And do you want the best for your daughter?
I do, yes, sir.
And you've had a hearing in CPS court on Valentine's Day where you gave an affidavit of relinquishment of your parental rights?
Yes, sir, I did.
Okay. So do you feel sorry for what you either did or failed to do for your daughter?
At the time, I wasn't aware, but yes, I do.
Okay. So you realize the judge is probably gonna send you to prison.
Yes, I do.
Are you asking for something maybe in the 20-year range as opposed to 35?
I am asking for leniency.
No further questions. That's a prosecutor may want to ask you something.
All right, in just one moment, my email went down. I did have the PSI report up, but the PSI report has disappeared on my system. All right.
Yes, sir, just a few if I may. Mr. Kennedy, my name is Zach Dunn. I'm one of the prosecutors in the Family Violence Division. I should have a few questions for you, and some of it goes to your statements in the PSI, which is the report that the judge is looking at right now. You basically mentioned on kind of the last page of it that you really kind of didn't know or were unsure of the fact. You said you had ignorance of your daughter's condition. She was diagnosed with cerebral palsy at birth, though, correct?
I do not know.
With respect to her abilities, things she was able to do, did you notice any kind of comparison between her and other 10-year-olds?
Actually, comparison between her and when I was going through high school, I noticed that there was children that were similar.
And are you aware of how much she weighed as a 10-year-old when the police came to the residence for the first time?
I believe she was at 27 pounds, but I can't remember.
27 pounds as a 10-year-old. Does that seem normal to you or abnormal to you?
I do not know. I mean, when I look at, when I remember how there were others that were her age, more or less, even, and when I was going through high school, I saw that they were about her size.
You're saying when you went through high school personally,
When I went through high school,
you knew of 10-year-olds that were around 20 pounds in weight, or?
we went to the kitchen cafeteria, and I saw others that were rolled around in wheelchairs that were about the same size.
And what did you make of the fact that Michelle, again, a 10-year-old, was unable to speak and barely even move when the police first interacted with her coming on scene? Is that normal behavior, you think, for a 10-year-old?
I think given that she had cerebral palsy, that it was normal.
And with respect to her diet, do you think it's appropriate to feed someone Oreos, milk, and Kool-Aid to sustain their life as a 10-year-old with cerebral palsy?
Michelle could not eat solid, so she couldn't even eat Oreos.
Okay, but at the time, does it surprise you, or is it surprising to hear now that y'all's statements at the time on scene was that, again, you fed her Kool-Aid, milk, and Oreos?
At that time, given that Numa was taking her to the doctors, and that the doctors were aware of what was going on, I thought everything was okay. Given that now I know that it's not okay, because that could have all been avoided with the surgery of a G tube, gastrostomy tube.
You said you know about that now.
I do.
So if police had never come and CPS was never involved, what do you think the future of Michelle's life would look like? Again, at the time she weighed 27 pounds as a 10-year-old. That was a few years ago.
Well, she did lose a lot of weight due to her being sick. It wasn't due to lack of us providing nutrition. It was due to her being sick that she lost weight.
No further questions, Ron.
All right,
That's
any
it, John.
follow-up?
No follow-up,
All right, may I
Right.
ask a question?
please.
All right, why was she never placed back in school?
When she was originally taken out of school due to the coronavirus.
All right, and then after
when
that?
we attempted to take her back to school, she could never keep the mask on. She would keep constantly pulling it off. And then they told her to no longer go back to school.
I'm sorry, what?
They told her not to go back to school until she can take care of that.
Okay. And I'm sorry, I'm trying to find the trial court certification form. Just one second. I'll have it. All right, so you're saying that they didn't allow her to come back to school because she continued to pull off her mask?
Yes, ma'am.
And the offense date on this is 2023. So help me, in 2023, were students still required to wear a mask?
I do not know, Your Honor.
All right, so you didn't take her back to school in the year of 2023.
No, Your Honor.
And I read the PSI report, and it said that you had personal insurance.
I did. Oh, I did.
All right, so at that time you had personal insurance, correct?
Yes, Your Honor.
How often had she seen a doctor?
I believe the last time she saw the doctor was in 2020. And I believe it was on a either annual or duannual checkup. I left that all to Norma to take care of.
All right, so the last time she saw a doctor was in 2020.
Yes, I believe so.
So did your wife, Norma, have the insurance card to take her to a doctor?
No, Your Honor.
All right, so you had the,
Wife, they just live together.
all right, so the person you lived with, were you in a romantic relationship with them?
Yes, Your Honor.
All right. And were you all living together as boyfriend and girlfriend or husband and wife?
Yes, Your Honor.
All right, and so you left her in charge of taking care of your child?
Yes, Your Honor.
And is she the biological mother of that child?
Yes, Your Honor.
All right, so you didn't give her your insurance card to take her to the doctor for emergencies?
I never was issued one. Everything was done electronic.
All right, so since 2020, you never took your child to the hospital, emergency rooms, or to see a pediatrician?
Personally, I haven't. I do not know what Norma has done.
All right, did you ever ask her, hey, she's not eating right, something's going wrong? Have you taken her to the doctor?
This will actually all happen recent, like because she got sick because of everything that happened. We took her to the hospital to Christus Santa Rosa at first. And
When was that? Was that in 2023?
yes, Your Honor.
All right, I'm talking about before 2023. Unless, and if I'm wrong, correct me. And I won't take offense to you correcting me. It appears that this is something that was happening over time. Am I right? The fact that she's not gaining weight, she's not eating?
No, Your Honor. The way we were giving her nutrition over the time period from her birth until the time that she got sick was the same constant method.
Okay.
And then all of a sudden she gets sick and she lost the weight.
So what was her highest weight? Because this is saying that she was 27 pounds at 10. So before she started dropping all of the weight, what was her weight as a 10-year-old?
I believe it was either at 40 or 45 pounds.
So 45 pounds, and then all of a sudden she's at 27 pounds.
Yes, Your Honor.
So you didn't think to take her to the doctor when she dropped down to 30 pounds?
I would be at work, so when I would come home, I'd always want to try to sleep or relax just before sleeping.
All right, and how far did you go in school?
For school, I graduated from St. Philip's College.
Okay.
I got my certificates for aircraft and power plant.
All right, thank you. Any other questions, defense?
No, Your Honor.
State, any other questions?
No, Your Honor.
All right, the court will hear argument. The state is opposed to the application. State?
Your Honor, this is an individual that essentially the state doesn't believe has taken responsibility. The litany of I don't knows and I'm not sure. This doesn't replace the fact that you're talking about a 10-year-old who had, as the medical facility diagnosed her with, quote, extreme prolonged malnourishment. 10-year-olds are somewhere in the range of above 70 pounds. This is a 27-pound individual who, through the defendant's own words, was fed Oreos, Kool-Aid, and milk. As if being a child wasn't a vulnerable enough position to be in the world, to be diagnosed with cerebral palsy at birth and have parents that don't take you because their insurance quote has expired and knew about well, first they knew about the diagnosis, but then they didn't know about the diagnosis, as they later said. The state would, of course, respectfully request that, the court take all these factors into consideration, given how this person completely disregarded the health of a young girl for many years on end, Your Honor.
All right, defense.
This case has a certain horribleness factor, especially to me as a parent. I can't imagine not feeding your child, and this is my second sentencing on this crime in a week.
Yes.
So I didn't know that many people weren't feeding their child. In representing my client, he's basically been clueless. I've had a very difficult time getting to him to understand what he did or did not do and what he should have done or should not have done. That doesn't condone what happened to his daughter. One thing I don't understand is how she went to healthcare providers and no one noticed anything, especially on the day in which she was taken to a healthcare provider a second time, and that's when she was taken into police custody, CPS custody. Okay, and you have terminated your parental rights, is that correct, sir?
Yes.
That's it, John.
All right, one final question. So what were you eating?
I would eat out a lot.
Okay. And did your weight ever drop at normally low?
No, Your Honor.
And how much did you weigh?
Before I was at 277.
All right, so if your weight went from 277 down to 100 pounds or 90 pounds, would you go to the doctor?
I would find out what's going on, yes.
Okay. All right, the court is going to deny your application. The court will find you guilty. I understand that there may have been other issues at play here, as far as maybe the mother was in charge of taking care of your daughter and during the day-to-day. So I am taking that into consideration. I'm going to sentence you to 34 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Which one? Yes, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Kennedy, I understand that you're probably hurt by what happened to your daughter. I do understand that. But children are 100% dependent upon adults. They're dependent on them to feed them. They're dependent on them to clothe them and for them to be educated. And you can't say your responsibility, I'm just outside working, somebody else is taking care of my daughter and I'm not noticing anything. You understand?
I understand, Your Honor, and I wish I did really know what was going on, like when CPS came by, my caseworker, she gave me all this paperwork
Mhm.
and I was reviewing it. It was at that moment that I understood
Okay.
the level of care that she demanded and she needed.
All right, well, good luck to you, okay?
Yes, Your Honor.
All right, thank you so much.
Thank you.
Thank you. Yes, thank you. Veronica, court is calling 2022 CR 9437, State of Texas versus Hillary Matthew Stillman. Can I have parties announced for the record for the state?
Your Honor.
Defense,
Todd Lessard for Mr. Steelman.
are you Mr. Stillman?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Hillary Matthew Stillman who was placed on community supervision for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on October 25th, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
All right. And state, it's the court's understanding that there is only one violation in the motion?
That is correct.
I see that that violation is a long violation to read. defense, did you read the entire violation of condition number 44 to your client?
We did, Your Honor. We went over that, and we're gonna be pleading true with an explanation.
All right. Any objection to the state just naming the condition as violation of condition number 4 as opposed to reading out the entire paragraph?
None, Your Honor.
All right, state,
Violated condition number 44, Your Honor.
how do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 44, the court could find it true, grant the motion, and sentence you up to 5 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 44?
Yes, ma'am.
Court will find violation of condition number 44 true. Is there a proposed agreement? All right, state, what are you requesting? All right, defense?
Your Honor, and we understand the state's position on revocation. Mr. Steelman already has a plan in place should the court revoke his community supervision for him to get back on his feet once he's released from prison. He was hoping for a more constructive rehabilitation environment with the SAFE. That was his mental health and physical health were not addressed properly. And he's currently being medicated for his mental illnesses. But we would ask the court to please impose the shortest sentence as possible for the court revocation is appropriate.
All right, Mr. Stillman, the court gives people chances in this court. If you have a drug or alcohol problem, if you have a mental health issue, the court gives that and tries to give that, but also protect the community. It shows in violation of number 44 that I recommended you for treatment and 2 times you refused to sign that. The court, as previously stated, is finding violation of condition number 44 true. Court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,200 fine, time and money for run concurrent. Did you pay the $57 to Bear County for drug testing?
I have not been yet. I've
All
not
right.
been out yet.
So there's to be $57 restitution to the Bear County Crime Lab. If you would like, I could recommend the therapeutic community for you at the prison. I have no control over them placing you in that program. It does not increase the length of time that you're in the program. Do you wish to be considered for therapeutic community?
Please.
All right. And I'll request the therapeutic community. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. This was not a plea bargain agreement. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes.
All right. Good luck to you. Okay.
Thank you.
You're welcome.